Yep.
Good morning, everyone. I'm David Barish, Pennsylvania Gaming Control Board Chairman. If you haven't already, please turn off the sound on your electronic devices. With us today is Fred Strathmeyer, representing Russ Redding, the Secretary of Agriculture, Jen Langen, representing Joe Torcella, the State Treasurer, and Sue Layton, representing Revenue Secretary Dan Hassel. Thank you all for coming. Quorum of the present. I'll call the proceedings to order. First order of business, the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
By way of announcements, the board held an executive session yesterday, Tuesday, June 26th, to discuss personnel matters and to conduct quasi-judicial deliberations relating to matters that are going to be discussed and voted on today. Next, I'd like consideration of a motion to approve the April 4th and May 2nd meeting transcripts. May I have such a motion?
Mr. Chairman, I move that the board approves the April 4th, May 2nd, 2018 meeting transcripts.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Danette Bixler-George, HR Director. Good morning.
Good morning. Good morning, Chairman. Good morning, board members. The Office of Human Resources has one motion for your consideration today relative to the hiring of two individuals. First, Connor Line has been selected as an Assistant Enforcement Counsel 1 under the Office of Chief Enforcement Counsel. He has completed the interview process, background checks, drug screening, and is recommended for hire by Chief Enforcement Counsel Cyrus Petrie. Second is Thomas Monahan, who has also been selected as an Assistant Enforcement Counsel 1 in the Office of Chief Enforcement Counsel. He too has completed the necessary background process and is also recommended for hire by Chief Enforcement Counsel Cyrus Petrie. Unless you have any questions, I would ask that the board consider a motion to approve the hiring actions as indicated.
Thank you. Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve the applicants for hire as proposed by the Human Resource Director.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thanks,
Thank
Danette.
you.
Doug Sherman, Chief Counsel.
Good morning, Chairman, members of the board. Our first agenda item is a temporary regulation relating to sports wagering. This is temporary regulation 125-217 and includes two distinct parts. The first is section 1401.5, conduct of sports wagering generally, which addresses some broad rules regarding the implementation of sports wagering, including but not limited to requiring that sports wagering certificate holders may only employ the services of one sports wagering operator, and that sports wagering certificate holders or sports wagering operators operating on behalf of a certificate holder may only offer one co-branded sports wagering interactive website or mobile application at this time. It also provides that integrity monitoring of sports wagering must be conducted by an independent third party on behalf of the certificate holder or operator. Future detailed regulations will be coming hopefully at the next meeting regarding more aspects of the integrity monitoring. Sports wagering certificate holders or sports wagering operators must also have the server located in the Commonwealth which is receiving the actual wager, and that's in order to comply with the Federal Wire Act. The other aspect of that regulation is to squarely and plainly place the burden on each of the certificate holders and operators for compliance with the Wire Act and other applicable federal laws. The second topic of the regulation before you it contains sections 1402 through 1406. These rules consist of licensing provisions covering sports wagering operators, sports wagering manufacturers, sports wagering suppliers, sports wagering gaming service providers, and all categories of individuals seeking to participate within the sports wagering industry. If there are no questions, I'd ask for a motion to approve temporary regulation 125-217.
Are there any questions or comments from board members? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt temporary regulation 125-217 as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter relates to a Office of Enforcement Counsel omnibus petition for an administrative order. Specifically, the Office of Enforcement Counsel is asking to remove 116 individuals from the board's involuntary exclusion list. Each of these individuals had been found to have attempted to enter a casino or did enter a casino while under the age of 21. They were brought before the board. In each case, the board has issued an order to place them on the exclusion list until their 22nd birthday or for 1 year, whichever is later. All 116 individuals have far surpassed that date and are eligible to come off the list. It was determined that for the sake of efficiency and making the list as effective as we can with persons who have committed acts that still require them to be on the list, removing these individuals will help shape the list and promote the effectiveness of it. And therefore, based on that, it would be appropriate to consider a motion to clean that list up and remove those people.
Any questions or comments from the board on this matter? May I have a motion?
Mr. Chairman, I move that the board approve Office of Enforcement Counsel's omnibus petition for removal of individuals from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next, the board has 5 other petitions before it for consideration. All of the petitions will be decided on the record by agreement of the parties. In each of the matters, the board has, in advance of this meeting, been provided with all of the documents of record. The first petition is that of Mountain View Thoroughbred Racing Association, and it's a request seeking an extension of time to file its Category 4 slot machine license application. On January 10th, 2018, Mountain View won the first Category 4 auction with a winning bid of $50,100,000, which was paid on January 12th, 2018. Pursuant to the Act, absent board approval giving a 2-month extension, Mountain View's application is due to be filed by July 12th. Mountain View has asked for the 2-month extension as provided in the Act and avers that since winning the auction, it's been working on identifying a specific location to place the Category 4 facility and evaluating multiple locations to find the best one. The Office of Enforcement Counsel has no objection to the request, and if granted, Mountain View's application will be due by September 12th of this year.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve Mountain View Thoroughbred Racing Association LLC's petition for extension of time to file its Category 4 license application as described by the Office of Chief Counsel.
Second it.
All in favor?
Aye.
All opposed? The motion's adopted.
Next before the board is Downs Racing's request to transfer and promote an employee who is currently employed in the surveillance department of Mohegan Sun Pocono to a position of compliance administrator at the property. The board's regulations require segregation of employees of a casino surveillance department from certain other casino staff and operations. This is done to limit the risk of collusion and malfeasance between various areas that are tied into surveillance. As a result, persons employed in surveillance are not free to simply change positions outside of that department without the board having reviewed and given approval. In this case, a Downs Racing employee is currently employed as a surveillance supervisor. His duties include conducting surveillance of gaming operations and coordinating with the security department and training, as well as training surveillance officers. The position of casino compliance administrator has recently become available and the individuals applied for that job. Mohegan avers that they would like to offer the position to this individual and that they have perceived no conflict with his service in the surveillance department. As the compliance administrator, he will be developing and overseeing compliance programs, managing internal controls, maintaining department policies and procedures, and reviewing employment documents for compliance and regulatory reporting. His duties will not be conducted on the gaming floor, and therefore the knowledge of surveillance would not be a possible impediment to this position. OEC also does not believe a conflict exists, and therefore has no objection to this request, and we would request a motion to approve it.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approves Down Racing's LP petition to permit Gavin Southworth to be employed as a compliance administrator as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next is the joint petition of Eldorado Resorts and Presque Isle Downs requesting approval of an amended corporate fee and shared service agreement. Eldorado is the ultimate parent company of Category 1 licensee Presque Isle Downs. The parties currently operate under a corporate fee and shared service agreement that was approved by this board in June 2017. There are two material changes to the parties' current agreement for which they seek approval. The First Amendment changes the formula for calculation of the corporate fee, which has the effect of increasing the corporate fee on Presque Isle by removing the income of low-performing Eldorado properties from the calculation. The second change sets a floor and a ceiling to the shared service fee to be paid by Presque Isle. Presently, there is no floor. There's also no ceiling. This amendment creates a fee of at least $800,000 annually, but no more than $1.5 million. The Office of Enforcement Counsel does not oppose the granting of the petition, subject to conditions outlined in their amended answer, which assure compliance by the parties with the agreement. Additionally, the petitioners have filed a motion to protect certain confidential information contained in their exhibits attached to the petition. OEC has no objection to that request, and the matter is ready for the board's consideration.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the joint petition of Eldorado Resorts and Presque Isle Downs, Inc. for an amended corporate fee and shared services agreement with the conditions requested by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next petition before the board is Jianming Lee's petition for removal from the board's involuntary exclusion list. By way of background, in October of 2013, Mr. Lee left his two children, a 15-year-old and a 2-year-old, in his car in the garage at Harrah's, Philadelphia, while he gamed inside for approximately 25 minutes. The Office of Enforcement Counsel filed a petition to place Mr. Lee on the exclusion list. A hearing was held, and ultimately this board placed Mr. Lee on the involuntary exclusion list on September 17th, 2014, for a period of 6 months, after which he could petition to be removed from the list. It's now been over 3 years since Mr. Lee was placed on the exclusion list, well past the 6-month period. There's no indication of any other violations by Mr. Lee, and he's requesting to be removed from the list. OEC has no objection to it, and we would suggest it would be appropriate for motion to approve.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve Jiangming Lee's petition to be removed from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The final petition before today was filed by the Office of Enforcement Counsel in a request that Awatif Kennedy be placed on the board's involuntary exclusion list due to 2 separate incidents at casinos. Specifically, in the first incident in August of 2017, while patronizing Parks Casino, Ms. Kennedy entered the food court and took several cookies valued at about $20 and then left the casino. Upon Parks discovering the theft, they have permanently evicted her from the Parks Casino. The second incident took place about 4 months later in December of 17, while she was at Sugar House Casino. While there, she went to a corner out of the gaming area, but still within the area of the gaming floor, and relieved herself on the carpet. She was permanently banned from Sugar House Casino. Ms. Kennedy filed an answer to the OEC petition in the matter, admitting to her actions, but expressing concern that she has started a new job and is concerned the placement on the public exclusion list will affect her career. The matter is now ready, based on that record, for the board to consider a motion.
Any questions or comments from the board?
Mr. Chairman?
Yes.
I just was wondering if you could explain the criteria that was utilized for what OEC used to put her on the list?
Yes,
exclusion list?
OEC has suggested that she could be placed on the list on two different grounds. It would be a person whose presence in a licensed facility would be inimical to the interest of the Commonwealth or of licensed gaming therein, which would include this specific provision: persons with a history of conduct involving the disruption of gaming operations within a licensed facility, or persons who have performed an act or having notorious or unsavory reputation that would adversely affect public confidence and trust in gaming. Those are the two provisions.
Okay. I think it's a bit of a stretch. Now, she also indicated that she is starting a new job and will lose her job over this. Is that what she indicated?
That was her concern expressed at the hearing that she attended, yes.
And she has been permanently evicted from both Parks and Sugar House.
That's correct.
So if we put her on this list, she's going to lose her job.
It's a possibility. We don't know. That was her concern.
Okay.
Yes.
No more questions.
Other comments?
Chairman, I got one.
Yeah.
And you said, well, she relieved herself, but that was not on the gaming. Was that on the gaming?
It was within the walls of the Sugar House facility. It wasn't necessarily in the gaming area. The petition said she went to a corner, presumably away from the machines and the other people that were gaming.
Okay, that's
Not in the
it, Chairman.
bathroom.
And there were no criminal charges for the theft?
There were no criminal charges for the theft. There was a disorderly conduct summary citation and one other summary that were filed because of the relieving, but those charges were then withdrawn, so she ended up with no criminal charges.
Do we know more about why they were withdrawn? Why those charges were withdrawn?
All we have is that we know that they were withdrawn, nothing further.
So local law enforcement did not see this serious enough to press this. It wasn't like she didn't get ADR or anything like that.
We have no indication that there was any diversionary program.
And did she offer any explanation or excuse or anything?
The record
From the behavior in the casino, whether with the cookies or the other matter?
The record reflected her testimony was that she had been on some type of medication. I don't know that publicly we want to really talk about what the condition was, but that the medication had affected her judgment. To our knowledge, there were these two isolated incidents that were not consistent with each other.
Does seem like a bit of a stretch. I tend to agree with Commissioner Santoni. Okay, any other questions or comments? Excuse me.
What kind of cookies were they?
Not in the record.
What was the question?
What kind of cookies were they?
Oh, what kind of cookies? That's an important point. Okay, having no further comments, is there a motion?
Mr. Chairman, I move that the board deny the Office of Enforcement Counsel's petition to place Abatif Kennedy on the PGCB involuntary exclusion list.
Is there a second?
I should second it.
Okay.
Second.
All in favor of denying the motion? Not denying the motion, denying the recommendation?
Yes.
Aye.
Aye.
Aye. All opposed?
Aye.
The motion is defeated. Thank you.
The motion was approved.
Well,
Defeated.
no.
Oh, defeated, gotcha.
Let me clarify.
Yeah.
The motion was to reject the recommendation.
Gotcha.
And I'm not sure whether that was a 6-1 or a 5-2, but the point is there was at
It
least
was
one-
rejected.
I heard at least one member of the supermajority vote no.
Okay.
To be clear, because it was the request of Enforcement Council to place her on the exclusion list, the motion was to deny that. There was no qualified majority, so she neither gets put on the list, doesn't get put on the list. I think
Is that right?
backwards here, but the result is she is not on the list.
I think we have a tiny piece of confusion here
Yes.
about this. Why don't we just take a small moment, come over here, Doug, and let's make sure we have the law right.
Was somebody I didn't hear.
God help us.
Yes.
Thank you. That was you.
Yes.
It's the same result.
Which is a majority outcome.
Okay.
You gonna resay it? Or somebody gonna resay it?
I don't know. I don't think so.
Pardon us for engaging in a grammatic understanding of what a triple negative means. Doug, perhaps for the record, you'd clarify where we are?
Yes, because there was no motion to place her on the list, which passed by a qualified majority vote, she will not be placed on the list.
Thank you.
Thank you.
All right.
Next before the board are 5 reports and recommendations received from the Office of Hearings and Appeals. The reports and recommendations, along with the evidentiary record for each hearing, have been provided to the board in advance of the meeting. Additionally, the persons involved have been notified that the board is considering their matter today, and they have the right to be present and briefly address the board. If any of these persons are present today when their name is announced, they should come forward to be sworn and briefly address the board. The first matter is Cicero Cadell Jr. On January 12th, 2018, the Office of Enforcement Counsel filed a petition requesting that Mr. Cadell be placed on the board's involuntary exclusion list, alleging that in March 2017, while patronizing Parks Casino, Mr. Cadell took a money clip he found on the floor of the casino and placed it in his pocket. Later that day, another patron reported that he had lost the money clip. Surveillance showed Mr. Cadell picking it up. Apparently did not return it, was arrested, charged with retail theft, and ultimately pled guilty to 1 count of receiving stolen property. He was sentenced to 6 months probation in order to pay $625 in restitution. Mr. Cadell requested a hearing, which was held on March 15th of this year. OEC appeared at the hearing, provided testimony and documentary evidence. Mr. Cadell appeared and testified on his own behalf. He did admit to his actions, but asked that he not be placed on the exclusion list. After hearing the evidence and testimony presented, the report and recommendation issued by the hearing officer is that he should be placed on the board's exclusion list, and that's the matter ready for the board's decision.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the placement of Cicero Cadell Jr. on the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
Opposed? The motion's adopted.
The next matter to be heard is report and recommendation regarding Tashuna Davis. By way of background, in June 2015, Ms. Davis submitted a renewal application for her gaming employee occupation permit. The Office of Enforcement Counsel issued a notice recommending denial based on the fact that she had an outstanding obligation owed to the Commonwealth in the amount of $745, resulting from an overpayment of unemployment compensation benefits. A hearing was held in May of 2016. Hearing was held in that matter on the recommendation of denial, and on May 25th of 2016, the board issued an order renewing her permit, which allowed her to continue to work as a table game dealer at Presque Isle Downs. However, the board placed a special condition on her, requiring her to make monthly payments toward the satisfaction of the obligation. In August of 2017, OEC filed a complaint to revoke her permit due to her failure to satisfy the obligation. She requested a hearing which was held in February of this year, and both OEC and Ms. Davis appeared, offering testimony and documentary evidence. The evidence presented showed that she had made 2 payments toward the lien. However, due to penalties and interest accumulating, the debt was now over $900. A report and recommendation has been issued recommending that Ms. Davis's permit not be revoked as requested, but be suspended until such time as she provides proof that the obligation has been satisfied, and that's the recommendation ready for the board's consideration.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding Tashuna Davis's gaming employee occupation permit in part. Specifically, I move that Ms. Davis' permit be suspended, but that the suspension be deferred for 30 days, during which she is provided a final opportunity to make a payment to the Department of Labor and Industry of at least $100, and to submit evidence of the payment and a payment plan resulting in full payment of the outstanding litigation. Failure of Ms. Davis to submit this information to the board by July 27, 2018, shall result in the suspension taking effect on Monday, July 30th, 2018.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Taylor Furco's matter is the next report and recommendation before the board. In June 2017, Ms. Furco was issued a permit to work as a table game dealer at Downs Racing. She is not currently employed with any licensed facility in the Commonwealth. On December 27th of 2017, the Office of Enforcement Counsel filed a complaint to suspend her permit after being notified that in September 2017, Ms. Furco was arrested and charged with drug and theft-related offenses. Specifically, she was alleged to have stolen and sold some of her mother's jewelry. A hearing on the matter was held on March 14th of this year. OEC appeared and offered testimony and evidence, and Ms. Furco also appeared at the hearing, testifying on her own behalf and providing documentary evidence. Ms. Furco admitted to the actions, expressed gratefulness to her mother for calling the police on the matter, and stated that Ms. Furco was dealing with a drug dependency issue at the time and would not have been able to get sober on her own without having law enforcement become involved. She testified that she's been placed into a drug court program and is complying with all necessary requirements. She also said she'd been sober for about 10 months and has obtained a full-time job. If she successfully completes the drug court program, which she would graduate in November of this year, she would be able to petition to have all of the charges expunged from her record. Notwithstanding her testimony, the hearing officer recommends that her permit be suspended until at least resolution of those criminal charges, at which point she could request to have the suspension lifted, and that is the recommendation that's awaiting the board's consideration.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopts the report and recommendation issued by the Office of Hearings and Appeal regarding suspension of Taylor Franco gaming employee occupation permit described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next report and recommendation before the board stems from Samantha Klein's request to lift the suspension of her gaming employee occupation permit. Ms. Klein was issued the permit in June 2017 and worked as a security officer at Sugar House Casino. In July of 2016, the Office of Enforcement Counsel filed a request for an emergency suspension of her permit after receiving notice that she'd been arrested and charged with several offenses, including a felony charge for aggravated assault on a police officer who was conducting a welfare check on her at the request of her mother. The emergency order suspending Ms. Klein's permit was signed by the board's executive director on July 5th of 2016, and after a hearing was upheld by this board in October of 16. In November 2017, Ms. Klein filed a petition to lift the suspension of her permit, indicating that the pending felony charge had been null prost. OEC filed an answer objecting to the petition, and a hearing was held in January of 2018, and with a second hearing February 20th of 2018. Evidence presented at the hearing showed that Ms. Klein has entered into a 2-year accelerated rehabilitative disposition program. The aggravated assault charge was null prost upon her acceptance into the ARD program, and to date, she has been compliant with the terms of the ARD program. Subsequently, a report and recommendation was issued recommending that the suspension of her gaming employee occupation permit be lifted, as the prerequisite felony charge upon which it was based has been null prost, and that's the recommendation for the board's consideration.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding Samantha Klein's request to lift the suspension of her gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
And the final report and recommendation before the board today pertains to Megan Spanbauer. In June 2016, Ms. Spanbauer submitted a renewal application for her gaming employee occupation permit to allow her to continue working as a slots attendant at Lady Luck Casino. In May 2017, the Office of Enforcement Counsel recommended denial of the application based on her being non-compliant with federal and state tax obligations, suitability issues, and her failure to cooperate with the background investigation. BIE had contacted Ms. Spanbauer on numerous occasions, giving her the opportunity to resolve the issues. There were 4 hearings held in the matter between July 11th, 2017 and March 1st, 2018. Following the original hearing, each additional hearing was scheduled to allow Ms. Spanbauer time to gather evidence showing her compliance with the federal and state tax obligations. OEC appeared each time offering testimony and documentary evidence as to the non-compliance. Ms. Spanbauer appeared and testified on her own behalf in the first 3 hearings. In fact, had provided evidence at one point that she had come into compliance with her federal tax obligations. At the hearing, though, she also testified that her state tax issue that remained unresolved resulted from the sale of a vehicle in 2010 or 2011 for which she was required to remit sales tax to the Department of Revenue, but that it had not been done. During the 3rd hearing held, Ms. Spanbauer indicated that she was in the process of making arrangements to satisfy that sales tax owed. Unfortunately, she did not attend the 4th hearing in the matter, and records reflect that she remains non-compliant with her state tax issues. A report and recommendation was issued recommending that her renewal application be approved, subject to a condition that she make monthly payments to the Department of Revenue and that she satisfy the debt within 18 months. The Office of Enforcement Counsel has filed exceptions to the report and recommendation, arguing that Ms. Spanbauer's application is incomplete due to her inability to show compliance with the Department of Revenue requirements, and that she failed to comply with the board's order throughout the investigation and the hearing process, and therefore is not suitable. I would note that our statute provides that a application cannot be considered by the board if it is incomplete, and that a application or an applicant that is non-compliant is incomplete. So therefore, we would suggest it's mandatory that the board deny the report and recommendation and deny her the renewal at this time because there is no complete application before the board.
Are there questions or comments from the board?
Yeah, thank you, Counsel. If we just had a matter a few instances ago where we imposed a suspension or I guess you would call suspension that was suspended, giving persons time to come into compliance. How is this either same or different from that instance?
This is different in that it's a recommendation for denial of renewal. It's not a matter of suspending or revoking an existing license. Her existing license is expired. She is here to renew it, or in essence, to grant a license for the next 5-year period. In this case, because she's non-compliant, she doesn't even have a completed application before the board.
If the board denies her renewal application because it is incomplete, immediately upon the denial, she can no longer work. Is that correct?
That's correct.
If she then makes payment of those tax delinquencies, then what happens?
She could then come back to the board
And reapply?
She would have, normally if you're denied a license, you are forbidden for a period of time from reapplying. But there is precedent with this board that if somebody remedies the deficiency in a prompt manner, which normally a denial like this will be great incentive to remedy those problems, the board does have the discretion to accept the application early and allow her to remedy it. The point here being she's been given over a year and 4 hearings, and nothing else has seemed to get her attention.
And does anything do we have anything in the record that reflects any, I don't know what word to use to characterize it, any indication of what her current employer would or wouldn't do depending on approval or denial?
Well,
I mean, they would have to, with a denial, they would have to suspend her, I guess.
well, no, they would terminate her.
They would terminate her employment, okay.
Other than that, we have no indication from the employer.
Just a tiny point, just want to make sure we're clear on this. In here and now, revenue is still clear that she has not met these obligations?
She's still non-compliant.
Thank you. Any other questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve. We're approving the report and recommendation if we're denying. I move the board, I'm very confused.
I'm sorry, the report and recommendation is that she be approved for licensure.
Okay, so if it is incomplete and I want to say it's incomplete and so she can't get a permit right now,
That would be
I'm moving to deny.
To reject the report
To
and
reject.
recommendation and to
Wanted to make
deny
sure
her
I had
renewal.
okay.
Yes.
Okay, Mr. Chairman, I move that the board reject the report and recommendation issued by the Office of Hearing and Appeal regarding Megan Spanbauer's employee gaming occupational permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
That concludes the matters of the Office
Thank
of
you
Chief
very
Counsel.
much. Sue Hensel, Director of the Bureau of Licensing. Good morning. You're not going to hit us with any triple negatives this morning?
I hope not. We'll see how it goes. Thank you, Chairman Barish and members of the board. Before the board today will be one video gaming terminal operator 2 video gaming terminal manufacturers, and 782 principal key gaming and non-gaming employee applicants. In addition, there will be the consideration of 2 gaming service provider applicants. The first matter for the board today is a conditional video gaming terminal, or VGT, operator license. The VGT operator applicant is Marquee by Penn LLC, doing business as Marquee by Penn National Gaming, Inc. Under the Gaming Act, the board may issue a conditional license to a VGT terminal operator. The Bureau of Licensing, Office of Enforcement Counsel, and Bureau of Investigations and Enforcement have reviewed the application, and I have provided you with the results of those reviews. I ask that the board consider a motion to approve a conditional VGT operator license for Marquee by Penn LLC.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the video gaming terminal operator conditional license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion is adopted.
Next for your consideration are 2 VGT manufacturer license applicants. The first is Bally Gaming, Inc., and the second is Konami Gaming, Inc. Each company is currently licensed in good standing with the board. Under the Gaming Act, the board may use an abbreviated process to consider the application of an already licensed manufacturer. The Bureau of Licensing, Office of Enforcement Counsel, and Bureau of Investigations and Enforcement have reviewed the applications and the status of the companies as licensees, and I have provided you with the results of those reviews. I have provided you with draft orders for the applicants and ask that you consider the companies for licensure as VGT manufacturers.
Enforcement Counsel has no objection.
Questions or comments from the board?
Mr. Chairman, can we just hold for a second?
Sure. Where were we?
Okay, sorry.
I guess I asked if there were any questions or comments from the board. Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the video gaming terminal manufacturer abbreviated licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
In addition, there is the approval of principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with a proposed order for 4 principals and 6 key employees. I ask that the board consider the order approving these licenses.
Enforcement Counsel has no objection.
Thank you. Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grants the principal and key employee licensing as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
There are also temporary principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 3 principals and 6 key employees. I ask that the board consider the order approving these licenses.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
In addition, there are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 566 individuals to whom the Bureau has granted temporary or full occupation permits, and 151 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving the order.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board grant the gaming employee occupational permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
There are also recommendations of denial for 4 gaming employee applicants and 4 non-gaming employee applicants. In each case, the applicant was notified that he or she was being recommended for denial and failed to request a hearing within the specified time frame. The Bureau of Licensing has provided you with orders addressing the applicants who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider a motion approving the denials.
Enforcement Counsel continues to request denial in each instance.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board deny the gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next for your consideration are withdrawal requests for gaming and non-gaming employees. In each case, the permit or registration is no longer required. For today's meeting, I have provided the board with a list of 31 gaming and 7 non-gaming employee withdrawals for approval. I ask that the board consider the orders approving the list of withdrawals.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the withdrawal of gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Finally, for your consideration are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 2 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Counsel has no objection.
Questions or comments from the board? I have a motion.
Mr. Chairman, I move that the board grant the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
That concludes the matters of the Bureau of Licensing.
Thank you, Susan. Office of Enforcement Counsel.
Office of Enforcement Counsel will present 16 matters today for the board's consideration, consisting of 5 consent agreements, 4 revocations, 2 suspensions, and 5 involuntary exclusions. The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Category 3 licensee Valley Forge Convention Partners, LP, doing business as Valley Forge Casino and Resort. The consent agreement will be presented by Deputy Enforcement Counsel Dustin Miller. Representatives for Valley Forge are present. I would ask at this time that those individuals introduce themselves for the record and that anyone not here as an attorney please stand and be sworn.
I'm Zane.
I do.
Good morning. Just for the purposes of introductions, my name is Michael Fabius at the law firm Ballard's Bar, representing Valley Forge with Fabius. With me to my left is Eric Pearson, Chief Executive Officer, spelled Pearson. And to his left is Dave Zerfing, Chief Financial Officer. His last name is spelled Zerfing. Thank you.
Thank you.
Good morning, Dustin Miller on behalf of the Office of Enforcement Counsel. This consent agreement arises from an investigation by the Bureau of Investigations and Enforcement into the awarding of free slot play at Valley Forge. The investigation focused on the authorization and issuance of discretionary free slot play at Valley Forge Casino Resort in 2015 and 2016. BIE's investigation revealed that discretionary free slot play was being issued by employees who could not authorize free slot play or were authorizing free slot play in an amount greater than they were authorized by Valley Forge's approved comp matrix. The investigation identified 557 free slot play transactions that may have violated Valley Forge's approved comp matrix by issuing $410,860 worth of free slot play in excess of what was authorized by Valley Forge's approved comp matrix. BIE's review found 355 instances where the employee issuing the complimentary could not authorize the amount of free slot play that was issued, and 202 instances where the employee issuing the complimentary could not authorize free slot play under the comp matrix. BIE's review also found that Valley Forge did not have standard operating procedures in place for its player development department during the time of BIE's review. Valley Forge believes that many of the identified transactions that did not comply with the approved comp matrix were the result of free slot play being issued by a lower level employee after the free slot play was previously authorized by a higher level employee. However, Valley Forge is unable to verify this contention because its computer system did not allow for 2 employee names to be associated with the transaction. Also, Valley Forge contends that all free slot play transactions are reviewed on a weekly basis by the finance, marketing, and player development departments, as well as the chief executive officer, to ensure that all discretionary free play is being issued at an appropriate level. However, Valley Forge could not provide documentation of such review taking place. Nonetheless, the free slot play transactions reviewed by BIE were in violation of Valley Forge's comp matrix as approved by the board. Valley Forge restructured its player development department in January of 2017 by terminating the department leadership and reorganizing it under the Vice President of Gaming and Player Development. The comp matrix is part of Valley Forge's approved internal controls. Board regulations and Valley Forge's executed statement of conditions require Valley Forge to adhere to the procedures outlined in its approved internal controls. On June 5, 2018, the parties entered into a consent agreement to settle this outstanding compliance matter. The terms of this agreement include a provision that Valley Forge Convention Center Partners, LP, shall reinforce existing policies to minimize the opportunity for similar incidents to occur in the future. Further, Valley Forge Convention Center Partners, LP shall pay a total fine of $50,000 and an administrative fee of $2,500. The fine and administrative fee shall be paid within 5 days of the consent agreement being approved by the board. Counsel for Valley Forge Convention Center Partners, LP is in attendance today to answer any questions you may have. Otherwise, the Office of Enforcement Counsel asks the board to entertain a motion to approve the consent agreement.
Thank you, Justin. Any comments from Valley Forge?
Yes, briefly, just to, first, we have no material disagreements with the presentation of facts by Office of Enforcement Counsel. We thought it would be helpful to speak briefly to how this occurred, the nature of the weekly review, and the remedial measure real quickly. One, Office of Enforcement Counsel explained that the issue with related to the system was that it would record one name, the employee at the computer issuing the free slot play at the time the customer was there. And in some instances, that issuer was not the person who was exercising the discretionary authority to issue the free slot play. Where that occurred commonly was with customers who had repeat offers. So the high-value repeat customers that came time and again and got X dollars of free slot play every time, they were authorized once, but the authorizer may or may not be there on property when the customer came back for repeat visits. So there'd be another employee exercising the non-discretionary role of actually issuing the free slot play, and the system simply did not record the second employee who had previously authorized it. To give a sense of scale, with the transactions at issues, there were 170 customers involved. 80% of the free slot play at issue was awarded to the top 20 individuals on that list. 90% of the free slot play at issue was issued to the top 40 individuals on that list of customers. So it's really the individuals that kept coming back and back and back, where this issue just happened with their one offer over and over again. Both the chief executive officer and the chief financial officer were personally involved in the weekly review to make sure that the level of play of the customers involved warranted the free slot play at issue. We want to note that that's important both from the business perspective and make sure that the return on investment is there, but obviously also in terms of fraud detection. These were real customers, and because of the high level involvement of the chief executive officer, the chief financial officer, and the leadership at Valley Forge, we have absolute confidence that every one of these free play transactions was issued to a real customer with a real business reason. In terms of remedial measures, this system is going to be adjusted so that the person at the computer has to have the capacity in the pursuant to the comp matrix to issue and authorize. So the system will only record one name, but only one name will be sufficient going forward. That does mean that we need to make sure that someone on property is eligible to issue the maximum offer that we have. So we've put through an amendment to increase the free slot play comp matrix so that there's always going to be a supervisor that has sufficient capacity in the comp matrix for any offer that we would put through. That way we have the ability to meet the customer's demand at any hour of the day. With that, we're here for any questions that you may have.
Are there any questions or comments from the board on this? Hearing none, May I have a motion?
Mr. Chairman, I move that the board approves the consent agreement between the Office of Enforcement Counsel and Valley Forge Convention Center Partners, LP, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thank you for coming.
Thank you very much.
Thank you. Thank you.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and manufacturer licensee Dytronics Financial Service LLC. The consent agreement will be presented once again by Deputy Enforcement Counsel Dustin Miller. Representatives for Dytronics are present at this time, and I request that those that this individual introduce himself for the record and state his name and his position.
Thank you, members of the board. My name is Kevin Greenberg of the firm Greenberg Traurig here for Dytronics. I also communicate the apologies from the Chief Executive Officer, George Vasilakis, who's dealing with a family medical crisis that he's had to go to California today. And, but he did come back east to meet with Enforcement Counsel last month in an attempt to address these issues.
Good morning, Dustin Miller once again on behalf of the Office of Enforcement Counsel. On May 11, 2017, the Bureau of Licensing made a violation referral to the Office of Enforcement Counsel regarding Dytronics for failing to timely file its audited financial statements. Dytronics is a licensed slot machine manufacturer whose license was last renewed by the board on January 13, 2016. Pursuant to Section 1207, subparagraph 4 of the Act, each licensed entity shall provide its audited annual financial statements to the board not later than 90 days after the end of the licensee's fiscal year. Also, in Dytronics' Statement of Conditions, Dytronics agreed to submit its audited financial statements not later than 90 days after the end of its fiscal year. Dytronics' fiscal year coincides with the calendar year. Thus, Dytronics' 2016 audited annual financial statements were due to be submitted to the board by April 3, 2017. Dytronics did not file its 2016 audited financial statements with the board until November 1, 2017. Dytronics' 2016 audited annual financial statements were 213 days late, and therefore Dytronics was in violation of the Act. Subsequently, while this matter was still pending, Dytronics' 2017 audited financial statements became due on April 2, 2018. Once again, Dytronics did not file its 2017 audited financial statements in a timely manner. Dytronics' 2017 audited financial statements were received by the Bureau of Licensing on April 30, 2018, 28 days late. Dytronics' audited financials were also late in 2015 and 2016 as well. Warning letters were issued to Dytronics by the Office of Enforcement Counsel for those violations. Following a filing of an enforcement complaint to resolve these matters, the Office of Enforcement Counsel and Dytronics entered into negotiations regarding the violations. On June 4, 2018, the parties executed the instant consent agreement to settle both matters. The terms of the agreement include a provision that Dytronics Financial Services, LLC, shall institute policies and controls and provide training and guidance to its employees who engage in audit and compliance functions, which will minimize the opportunity for a similar incident to occur in the future. Further, Dytronics Financial Services, LLC shall pay a total fine of $24,100, which represents a $100 per day civil penalty for each day that Dytronics' audited financial statements were late in 2017 and 2018. They shall also pay an administrative fee of $2,500. Counsel for Dytronics Financial Services, LLC is in attendance today to answer any questions you may have. Otherwise, the Office of Enforcement Counsel asks that the board entertain a motion to approve the consent agreement.
Do you have any comments at this time?
No, Your Honor, no members of the board. Mr. Miller did an adequate job of stating the facts. Mr. Vasilakis asked me to convey to you his apologies. He knows this is unacceptable. They've changed the auditors. They've changed the warehouse manager, which is responsible for the inventory problems that led to these delays. And they're committed to do better in the future. They'll be before the board in the next few months on renewal anyway, and so they'll be back before you shortly. And they know that they have to convince the board that they're worthy to continue their role in the Commonwealth.
Are there any questions or comments from the board?
Vasilakis, Vasilakos, first name George. He's the Chief Executive Officer, co-founder, and primary owner of the company.
If you could, I'd just like to ask, as I understand this, there were warnings in prior years, and then apparently no one took them very seriously. I don't want to characterize, but that's what it appears, if you're, whatever, 6, 7 months late, and then yet again in the current, in the one that would have been due in April of this year. Can you give me any insight into how many warnings does a company need before they realize they got a problem?
So I think it's safe to say that they did not take the earlier year warnings sufficiently seriously. They certainly did not get to Mr. Vasilakis' attention. The 2017 filing delay did. At that point, he made changes to the operations, and then, to his great embarrassment, those changes did not effectuate what he needed to do to be on time. Now, it was only 28 days late, and if it was not for the past history, I suspect a warning letter would have sufficed and it would have been done. That's not good enough, and he knows that, and we know that. And we're not in, the changes have been made. The new people are in place. They are up to speed. The audit will start January 1 of next year as opposed to sometime in March, and they will get it done. As you know, at the end of quarters, things get ugly.
Yep.
And that just happened at the end of the quarter this year. I want to say it's an excuse, but it's not really an excuse. It's not a good excuse.
I just want an
It's not a good
explanation.
excuse.
I don't need an excuse. An explanation is sufficient.
So the answer is they didn't do a good enough job letting him know in 15 and 16. In 17, they did. We made changes, and it just took some time for those to run through. And that's why we got it done, albeit 28 days late this year.
Well, 28 days is better than where we were. Hopefully, we'll see no more.
Small
of this.
progress, yes.
Thank you very much. Is there a motion?
Mr. Chairman, I move the board approve the consent agreement between the Office of Enforcement Counsel and Dytronics Financial Services as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you for coming.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Gaming Level 2 permittee and key employee license applicant William Gregory. The consent agreement will be presented by Senior Enforcement Counsel Beth Manifesto.
Good morning, Beth Manifesto, M-A-N-I-F-E-S-T-O, on behalf of OEC. This matter involves William Gregory. Mr. Gregory applied for and received a Gaming Level 2 permit from the board in May of 2012 and applied for the renewal of the Gaming Level 2 permit in September of 2015. Mr. Gregory was promoted to the Director of Table Games, and in July of 2016, he applied for license as a key employee. The Office of Enforcement Counsel considered information obtained by the Bureau of Investigations and Enforcement during Mr. Gregory's key employee, as well as his G2 permit background investigations, a compliance report issued by the Bureau of Casino Compliance, and a sworn interview of Mr. Gregory conducted by the Office of Enforcement Counsel to assess his suitability. Subsequently, the Office of Enforcement Counsel issued a recommendation of denial to Mr. Gregory regarding his key employee application. On or about May 25th of 2018, the Office of Enforcement Counsel and Mr. Gregory entered into a consent agreement wherein Mr. Gregory admitted to the following. First, that he knowingly instructed employees at Presque Isle Downs and Casino to not remove the first card from the table shoe when a new dealer tapped into the game, in violation of Section 633A.7 of the board-approved regulations. The Bureau of Casino Compliance documented 16 violations of this regulation, and these incidents were part of a consent agreement with Presque Isle Downs, Inc., which was previously approved by the board. During his sworn interview, Mr. Gregory admitted that at the time he was aware that his instruction to the table games dealers would result in a violation of the regulations. Second, Mr. Gregory failed to provide copies of his federal tax returns for the years 2011 and 2012 to BIE during his background investigation. And third, Mr. Gregory has an outstanding tax liability of approximately $14,000 to the United States through the Internal Revenue Service. Mr. Gregory provided a copy of a payment plan for the outstanding tax obligation during his 2015 background investigation. However, he failed to provide proof of any payment pursuant to the plan, apart from one payment made 2 days prior to his sworn interview with OEC in December of 2017. Documentation obtained during Mr. Gregory's background investigation revealed that no other payments had been made toward that debt. Mr. Gregory resigned from his position at Presque Isle effective May 22, 2018, and entered into this consent agreement. The terms of this consent agreement require Mr. Gregory to surrender his gaming Level 2 permit with prejudice, that his application for key employee licensure be withdrawn with prejudice, and that he be prohibited from applying for or holding any credential or authorization for a minimum of 5 years from the date of the board's order in this matter. Mr. Gregory informed me that he would not be present today, and he desired the consent agreement move forward without his being present. As a result, the Office of Enforcement Counsel requests that the board approve the proposed consent agreement, and we would be happy to answer any questions.
Thank you. Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve the consent agreement between the Office of Enforcement Counsel and William Gregory, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next two matters on the agenda for the board's consideration arise out of the same fact pattern. As a result, I would ask that those parties to both of those consent agreements come forward. The first consent agreement is between the Office of Enforcement Counsel and gaming-related gaming service provider licensee InBet Gaming, Inc., and the second is a consent agreement between the Office of Enforcement Counsel and manufacturer applicant American Gaming Systems. Both consent agreements will be presented by Senior Enforcement Counsel Beth Manifesto. Representatives for InBet Gaming and AGS LLC doing business as American Gaming Systems are present at this time. I request that those individuals introduce themselves for the record, and anyone who's here not as an attorney, please stand and be sworn.
Good morning, board. My name is Ronald LaDuca. I'm the president of InBet Gaming. I'm sorry. Good morning.
We can't hear you.
I'm sorry. My last name is L-A-D-U-C-A. Ronald LaDuca, and I'm the president of InBet Gaming.
Thank you.
Yes.
Good morning, Mr. Chairman. Frank DiGiacomo, D-I-G-I-A-C-O-M-O, from Duane Mars on behalf of AGS LLC.
Thank you.
Before we get started, housekeeping matter. In both consent agreements, we found a typo paragraph that may have caused some confusion. On page 11 of the InBet Gaming Consent Agreement, I believe it's page 11, and page 11 of the AGS consent, or page 9, 11 on both consent agreements. The last two paragraphs before terms of the agreement have been deleted. We have new executed consent agreements. Deleting those paragraphs, that would cause all the figures to be correct. The figures in the table are correct. As a result, I can provide the board a copy of the new consent agreement with the page.
Thank you.
Okay.
Okay.
Once again, that would be page 11. First, the last two paragraphs before the terms of the agreement have been deleted. Okay.
Good morning. Beth Manifesto on behalf of OEC. And was there no objection to one fact pattern being read? That's fine? Okay. InBet Gaming has been a certified gaming-related gaming service provider since February of 2012, with its certification renewed by the board in October of 2016. InBet creates card games and modifications to existing games. InBet leased its games to casinos in exchange for a monthly fee and had games in use at licensed Pennsylvania facilities. AGS is a manufacturer and distributor of slot machines, table games, and table game products. AGS has never received authorization, certification, registration, or licensure from this board. On September 26, 2014, AGS entered an intellectual property purchase agreement and acquired all right, title, and interest in the patents of various InBet games, as well as all related assets, including all future revenue from games already placed in Pennsylvania casinos. On October 31st of 2014, AGS executed a distribution agreement wherein InBet would promote, market, and distribute AGS's products in jurisdictions, including Pennsylvania. In exchange, InBet would earn an annual fee and a commission. On November 2nd of 2015, AGS filed applications with the board for licensure as a slot and table games manufacturer. The submitted applications did not make it known that they had a business relationship they did not have a business relationship noted between AGS and InBet, nor was it disclosed during the background investigation. On August 29, 2017, parties entered an asset purchase agreement for the right, title, and interest to previously purchased games as well as new games. This agreement also sold the physical and intellectual property assets related to the games, which included the contracts InBet had with Pennsylvania casinos. For all three agreements, InBet invoiced, collected, and deposited funds from Pennsylvania casinos into its account. InBet would determine what it was owed, and it would then issue a check for the remainder of the funds to AGS. This process occurred until May of 2017, when PGCB staff independently discovered that an unlicensed and unauthorized entity was receiving gaming-related compensation through a certified gaming service provider. The Office of Enforcement Counsel was informed and issued correspondence on August 29, 2017, requiring that all future funds owed to AGS received by InBet be placed in escrow until further notice. As of September 7, 2017, 4 games owned by AGS were leased to 10 Pennsylvania casinos. The total amount invoiced by InBet in Pennsylvania was approximately $407,016. Of this, $351,271.40 was owed to AGS. Under the agreements, InBet was owed $55,744.60 in Pennsylvania-generated revenue. Both AGS and InBet have been cooperative in the resolution of this matter. In regard to AGS, the described activity resulted in AGS's violation of Section 437A1 and A2 of the regulations, as it had not applied to the board for certification as a gaming-related gaming service provider prior to engaging in business with InBet. AGS did not disclose its relationship with InBet, and although it was not authorized or certified, AGS was able to profit from the Commonwealth's gaming industry. The OEC asked the board to adopt the submitted consent agreement and impose a civil penalty of $351,000. I'm not going to be able to get this number out. I apologize. $351,271.40 and an administrative fee related to the preparation of this agreement in the amount of $2,500. As to InBet, its statement of conditions were violated, and it failed to comply with the Act and regulations when InBet did not notify the Pennsylvania Gaming Control Board regarding its business relationship with AGS, and through its role in assisting a company which was not authorized or certified or registered to receive gaming revenue. The Office of Enforcement Counsel requests the board approve the consent agreement negotiated with InBet Gaming and impose a civil penalty of $55,744.60, as well as the administrative fee of $2,500 for staff expenses related to the agreement. And we are all happy to answer any questions you may have.
Thank you. Are there any comments from InBet on this matter?
Chairman, I just would like to apologize to the board. It was just an honest mistake. I've been licensed with PA for over 6 years. I comply with all the regulations. I'm licensed in over a dozen other jurisdictions throughout the country, and it was just an honest mistake, and I apologize.
American Gaming Systems, do you have any comments at this moment?
Yes, Mr. Chairman, thank you. I agree with Mr. Leduca. Mistakes were made, and mistakes by AGS were made as well. In July 2014, AGS began a table games business, and at that time entered into, or shortly thereafter, entered into an agreement with InBet Gaming.
What was the time, I'm sorry? You said July of?
July 2014, AGS, which up to that date was a gaming equipment, a slot machine manufacturer primarily, expanded into table games. They entered into a series of agreements, as Ms. Manifesto set forth, with InBet Gaming to acquire the intellectual property interest in certain game themes that Mr. Leduca had developed over the years. Those agreements were multi-jurisdictional. We acquired the intellectual property for existing games that were on casino floors in over a dozen jurisdictions, including Pennsylvania. So those games that Mr. Leduca had distributed and had IP agreements with Pennsylvania casinos were in existence at the time AGS entered into this agreement. The agreement, inartfully and in hindsight, in error, tried to make accommodations for those jurisdictions where AGS was not licensed. Admittedly, the accommodation with respect to Pennsylvania was not sufficient. What AGS should have done at that time.
Try to keep your voice up. We're having trouble.
I'm sorry.
Thanks.
What AGS should have done at that time was the agreement should have been clearer. The funds from the Pennsylvania casino should not have flown through, albeit through InBet to AGS. Thereafter, in 2015, as Ms. Manifesto stated, AGS did file an application for a slot machine manufacturer license and a table games manufacturer license, neither of which, by the way, were necessary for the arrangement, for the intellectual property arrangement for these games. During the course of the investigation, there were disclosures made. Admittedly, the relationship between InBet with respect to those agreements was not clearly disclosed. The game themes themselves were...
Can I stop you there just as you're going through this? Don't mean to be picky here. You said not clearly disclosed. Were they disclosed in any fashion at all?
Well, I would submit, and I don't want to parse words, but I have an exhibit to the manufacturer license which set forth the game themes. So, for example, Crisscross Poker is one of the game themes. Crisscross Poker was identified as a game theme, and supplemental information with respect to that was disclosed. What was not disclosed was the contract with InBet Gaming.
Okay.
And that was done in error. It was not clearly disclosed. And there were other supplemental requests for example, software, third-party software license agreements. This was not a software license agreement, so again, the disclosure was not made. Again, in error. Mistakes were made. That's our main point here. This certainly fell between the cracks. And then once we were made aware of it by Gaming Control Board staff in the course of our suitability investigation, we immediately provided all the information. We've been, we think, cooperative with BIE since then and with Mr. Petrie's staff, and provided all information. And again, the company admits mistakes were made, and that's why we are in agreement to pay the significant civil penalty.
One second. Do you have any response to what the gentleman for American Gaming Systems just said?
I think that's
at this point.
I think he's been pretty accurate in the assessment of everything. It was discovered through gaming operations going through the AGS website, listed games. The games were on the application, but we didn't know that they were the same games.
You didn't know it was a contractual arrangement there.
Exactly. So immediately upon finding out, we requested that they place all future monies in the escrow account and give us monthly statements with regard to the escrow account. I have the latest statement right here. Based upon the fine is based upon the activity that was done when we had no idea that the activity was going on, and also based upon the time that it took to complete the investigation to verify everything that occurred. That went until December 31, 2017. So that's what the fine is based based on. There are additional monies that have been placed in escrow. AGS was, I believe, last summer scheduled to be licensed by the board at I think a July meeting of 2017. We pulled that licensure back when this was discovered, and so they're waiting to be licensed. So everything depends, the timing of everything is going to basically depend upon how the board rules in this matter. The other thing, all these game themes are presently in Pennsylvania casinos. They're very popular. So we didn't want to interrupt or disrupt the gaming operations and have the casinos harmed by removing those games. So we allowed those games to stay in place because InBet is licensed, and the revenue from those games that were supposed to go to AGS are now sitting in an escrow account.
And Mr. Chairman,
I think, if I could, I believe Mr. Rizzuto
No, I
has
just didn't know
something
if I was
he wanted
relevant, but I just wanted to know, let the board know that all the acquisitions, the casinos were notified that AGS did take over the games. So it was disclosed to the casinos. Just unfortunately, mistakenly, it wasn't to the commission.
Okay, thank you.
I would also note that AGS has bolstered its compliance staff internally. There's a new head of regulatory compliance. Procedures are now in place to assure that this does not happen again. I believe that the company has been very responsive to all requests and did our own investigation as to the circumstances that led to this failure to clearly disclose what obviously should have been disclosed.
And the fine is reflective on those operations that occurred. So basically, the Commonwealth has, for lack of a better word, taken ownership of those games for those years they were in operation in the Commonwealth without authorization by this board. So we're going to get the revenue that was generated during those unauthorized years.
Okay. Are there questions and comments from the board on either of these matters?
Yes.
Nobody
Questions
from
and comments from board members on these
nobody from AGS is here?
Unfortunately, General Counsel Vic Gallo and the head of regulatory compliance, Amy Lawrence, are out of the country at a previously scheduled matter. It was our preference to get this matter before the board as soon as possible, and they had committed themselves to travel internationally on other matters, and they do extend their apologies, but that's the circumstance as to why they're not here.
Anything else, Commissioner Logan?
No, that's unfortunate.
Mr. Commissioner, I would add that we have repeatedly offered to make Vic Gallo, General Counsel, Amy Lawrence, anyone at the company available to BIE to explain this situation in greater detail. We continue, we do have a pending license application pending before this board, so they remain available to answer any and all questions with regard to this matter and the company more broadly.
Okay, thanks.
Yep. Couple of comments. One, I view this very seriously in my years that I've sat on this board, because the entire implication of the regulatory structure within this Commonwealth is to make sure we know who we're doing business with, who's behind it, what's it all about, in order to ensure the fairness and integrity of the gaming process within the Commonwealth and who's involved with ownership interests. So this is a very fundamental breach in my judgment. And the word mistake, I'd be really interested, because I assume our regulations are clear about the transparency of who is supplying goods and services into our casinos. And so I'm just concerned this has implications for going behind the back and defeats the purpose of what we are about and what the original act in 04 is about, and the regulations there too.
And Commissioner Jewell, I might add that this is not the first time something like this has happened. This board dealt with a similar situation in 2012 in which multiple consent agreements were entered into.
think I had the same comments.
Commissioner, if I may address your concern, and I wholeheartily agree, and Mr. LaDuca can support this. These games were put into Pennsylvania casinos under Mr. LaDuca's license properly. So when we acquired the intellectual property to the games, that's where the breakdown in the regulatory process occurred. At that time, notification should have been provided, and AGS should have moved forward with perhaps a gaming-related gaming service provider application at that point, even though it was not prepared to make the full manufacturer license application, which it did several months later. So I'm not making an excuse. I'm just kind of explaining the circumstances. And again, mistakes were made, admittedly so.
Thank you, Counsel.
I have a comment, I guess, directed to AGS and InBet, and then some questions for Office of Enforcement Counsel. I just want to echo what Commissioner Jewell just said. Kind of boggles my mind that this was some simple oversight when this board regulates and registers and licenses everyone from the janitor on a gaming floor, and I sit here month after month and suspend people making less than $10 an hour for acts that are described by the Act as requiring action, but I think the impact of them into the integrity of gaming in Pennsylvania are minuscule compared to the potential impact of the integrity of gaming and a strong regulatory structure here are from the acts here. So I just wanted to echo that. To the Office of Enforcement Counsel, I believe it is the chairman's intent, and I will specifically say I need to have a discussion before I'm ready to vote on this, and particularly I will want to review what you just gave to us with regard to changes. However, when I was reviewing this matter prior to this meeting, I was having a real problem with the penalties that were being recommended by this consent agreement vis-a-vis the actions that were taken. And my blush, which may have been inaccurate or have been accurate but being corrected by what you're giving me, was that for what I was viewing as a very egregious issue, the penalties seemed to basically be what I'll call a give back to ground zero, if nothing better. Okay, whatever we would have gotten beforehand, we will now collect now by this consent agreement. And I didn't see anything that went beyond that indicated the seriousness of the violation of our regulatory process. Could you explain to me again the money and the fines vis-a-vis the gains of the actors here, AGS and InBet, and then what it is that you're recommending above or beyond that?
Okay, so the games were in play at Pennsylvania casinos from 2014 through 2017, and they're currently in play. The money for after the 2017 period are sitting in escrow. Okay, and some of the money from the 2017 is also in escrow from August to December. The total amount of money made through December 31, 2017 was $407,016.
That is profit to whom?
That is profit to InBet and AGS.
So combined profit.
407, if you turn to page 10 of the consent agreement, that table, 407,000.
That's a new,
We're at a disadvantage.
We're at a
We don't have this
disadvantage. We don't
document.
have that.
Okay.
David has one
It's in
copy.
your old one also.
Oh,
If we take a brief break, I'll share this.
okay.
But it's $407,016. The penalty, we're taking the revenue that AGS would have earned during that period of $351,271.40. We're also taking the revenue that InBet earned during that period of $55,744.60. The casinos are making revenue from these games. The casinos do nothing about this, so we're not removing the games from operation. We're not punishing the casinos. What we're saying is, since you're not licensed and you didn't do what you're supposed to do, we are going to take the revenue from those games operating in our state. The punishment is that they lose their revenue, and they gave us those games for operation for free, and we get the revenue from those games, because they did generate significant revenue during that time period. So
Okay, so you're saying the 406, the 351 plus the 55, which adds up to 406, 407, was their profit that, had they been properly licensed and registered, the Commonwealth wouldn't have gotten, they would have gotten.
Exactly.
Okay.
And InBet, realistically, was licensed properly and was entitled to that $407,000. But because they entered into this agreement with AGS, we're taking their revenue also.
Okay. That makes, clarifies things for me. Thank you, Mr. Chairman.
So, any other questions up here at the moment?
Mr. Chairman, if I may address Commissioner Mandarino's
Please.
excellent point with respect to integrity. AGS is licensed in over 250 jurisdictions, gaming jurisdictions worldwide. It understands its regulatory obligation. I want it to be clear, though, that the integrity of these games was not compromised, right? The players had a fair game, and the games were approved by Pennsylvania regulators. It was the funds that flowed from the casinos previously to InBet, and albeit improperly to AGS for a period of time, is really a question, and admittedly so through a series of mistakes by AGS, which they fully accept responsibility for.
Counsel, I think your point is fine as far as it goes, but under the regulatory process and structure, we still have to know who the companies are and who's behind those companies.
Understood.
And without the ability to know that, the entire matrix is not completed.
Understood. And a consequence of operating in multiple jurisdictions are different regulatory requirements. Of no moment to this commission, I'm sure, the structure did not violate the requirements of many regulations, the contractual structure that was in place. Unfortunately, it violated the regulations and statutes of this Gaming Control Board.
Thank you.
If I could, and I think we can bring this to an end for the moment. The integrity of the game itself, in my opinion, is a red herring. No one raised the question of the integrity of the game. Hear me out. The integrity of what we do for a living is, I'm seconding comments that Mr. Jewell made 15 minutes ago, goes to the heart of the integrity of what we're here to do. If we don't know who the heck owns what and where money is flowing, we are in no position here to assure the public of what is going on financially in the Commonwealth. That's a different kind of integrity, and that's what we're talking about here.
I stand corrected then, but I would add that AGS filed an application for a slot machine manufacturer in, I believe it was October 2015, well before we were aware of this mistake.
Mm-hmm.
We were availing ourselves of the regulatory process in Pennsylvania in hopes of eventually being licensed. Again, there was no attempt here to circumvent the regulatory obligation or the integrity of that process. Mistakes were made. Once those mistakes were discovered, we've made every effort, at least in our opinion, to cooperate with the regulators to get to the bottom of this, and are willing to pay this, what I would characterize as a significant financial penalty.
If you
Follow up when you're done.
if you didn't have the appropriate approval to have this arrangement, then by definition, you didn't have the approval to collect the revenues.
Correct.
And you'll forgive me, but I used to be a federal prosecutor, and we caught people stealing money. We didn't just make them give the money back. That's my comment. Which is, it appears that what this settlement involves is the depriving them of the result, of the consequence of the money that they improperly were allowed to earn in the Commonwealth. And that certainly is not, to me, I, for one, am not sure that's adequate resolution, because that's not what we do. This is really not a fine. It's a disgorgement, and that troubles me. With that said, if there's other comments, go ahead.
Further question for Office of Enforcement Counsel. I understood you to say earlier that AGS has a pending application for a license, but it's all kind of wound up in this. Is this correct?
Yes, last summer, it was AGS was scheduled to be licensed by the board. We pulled that licensure back in order for us to further investigate this matter. Okay. Other than this matter, they're suitable.
Okay. Well, that's so where I was going with this is I know when we review applications for licensure and suitability of all of the principals and key employees, there are significant background checks that happen as a regard to that. My question is, to the extent that you can disclose at this point, because that matter isn't necessarily before us, but in your doing that, have your reviews gone back as far as everyone involved when they first started this relationship in the Commonwealth in 2014? And if not, I would suggest that they should.
If those reviews have been updated.
Okay. Thank you.
I'd like to take a brief recess. We'll be back.
Thank you. Oh, I thought Mayor was.
Before we proceed, it should be obvious, hopefully to everybody in the room, this is a matter of great significance to us that we take extremely seriously. And an awful lot of time has been spent on this matter up here. Having said that, do I have any motions?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Council and Inbeck Gaming, Inc. as described by the Office of Enforcement Council.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Is there another motion on American Gaming Systems?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Council and American Gaming Systems as described by the Office of Enforcement Council.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you. Thank you, Mr. Chairman. Thank you, Commissioners. Thank you.
The next 6 matters on the agenda consist of enforcement actions in which the Office of Enforcement Council filed complaints seeking the revocation of 3 non-gaming employee registrations, 1 gaming 2 permit, and the suspension of 2 non-gaming employee registrations, which were issued by the board. Each complaint has been filed with the board's Office of Hearings and Appeal and properly served upon the person named in each complaint. The person named in each complaint failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Council filed a request for default judgment and properly served the same upon each named individual. Therefore, the facts in each complaint are deemed admitted. All filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, we will provide a brief summary of the facts and request the appropriate board action.
Good morning, Chairman, members of the board. John Crowe, C-R-O-H-E, for the Office of Enforcement Council. The next matter for the board's consideration is the suspension of the non-gaming employee registration held by Christine Cromer. Ms. Cromer has been charged with 2 counts of filing a false police report. These charges are currently active and listed as awaiting trial. The Office of Enforcement Council now requests that the board suspend the non-gaming employee registration held by Christine Cromer.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the suspension of Christine Cromer's non-gaming employee registration as described by the Office of Enforcement Council.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Good morning, Chairman, members of the board. Sarah Kolesar, K-O-L-E-S-A-R, Assistant Enforcement Counsel with the Office of Enforcement Counsel. The next matter on the agenda for the board's consideration is the revocation of the non-gaming registration issued to Rachel Molish for stealing approximately $150 from a cash drawer while working as a cashier host at the Meadows. Ms. Molish completed a team member voluntary statement form in which she admitted that she stole the money. Subsequently, Ms. Molish was terminated from her position with the Meadows. At this time, the Office of Enforcement Counsel requests that the board revoke the non-gaming registration issued to Ms. Molish.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Rachel Molish non-gaming employee registration described by the Office of Enforcement Council.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Good morning, Chairman, members of the board. Tamara Haken, H-A-K-E-N, with the Office of Enforcement Council. The next matter on the agenda for the board's consideration is the revocation of the non-gaming employee registration issued to Samantha Nicholson. Ms. Nicholson was previously employed at Lady Luck Casino. On December 22, 2017, Ms. Nicholson was terminated from her employment after admitting to taking $100 in gift cards that belonged to another employee who had won them through an employee promotion. OEC requests that the non-gaming employee registration issued to Samantha Nicholson be revoked.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Samantha Nicholson's non-gaming employee registration as described by the Office of Enforcement Council.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Good morning, Mr. Chairman and members of the board. My name is Ashley Gabriel, G-A-B-R-I-E-L-L-E, with the Office of Enforcement Council. Next on the agenda for the board's consideration is a complaint seeking the revocation of the non-gaming employee registration issued to Jonathan Sampson. Mr. Sampson was previously employed as a bartender at Valley Forge Casino Resort in King of Prussia, Pennsylvania. A review of transactions completed by Mr. Sampson in August 2017 revealed that he took cash belonging to Valley Forge in approximately 53 transactions between July 17, 2017 and August 17, 2017. Mr. Sampson was terminated from Valley Forge on August 18, 2017 for altering checks for personal monetary gain. At this time, the Office of Enforcement Counsel requests that the board revoke the non-gaming employee registration issued to Jonathan Sampson.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the revocation of Jonathan Sampson's non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Good morning, Chairman Barish, members of the board. David Tepper, T-E-P-P-E-R, on behalf of the Office of Enforcement Counsel. Next on the agenda is a request to suspend Kesha Williams' non-gaming employee registration. Ms. Williams was charged with conspiracy, endangering the welfare of a child, possession with intent to deliver a controlled substance, forgery, possession instrument of a crime, and related offenses related to her alleged involvement in a conspiracy to distribute cocaine and forge credit cards. These charges are currently pending before the Court of Common Pleas in Monroe County, and at this time, the Office of Enforcement Counsel requests that the board revoke the non-gaming employee registration of Kesha Williams.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the suspension of Keisha Williams' non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Good morning, Chairman, members of the board. Benjamin Farrell, F-E-R-R-E-L-L. The next matter for consideration is the complaint for revocation of the G2 employee permit issued to James Smith. Between March 1st, 2018 and March 7th, 2018, Mr. Smith stole a total of $5,000 in gaming chips from Harris, Philadelphia, while on a shift as a table game supervisor for Harris, Philadelphia. On March 7th, 2018, Harris, Philadelphia terminated Mr. Smith's employment. At this time, OEC requested the board issue an order revoking the G2 employee permit issued to James Smith.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of James Smith's G2 employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The remaining matters on the agenda consist of enforcement actions in which the Office
One
of
second, please. Hold on.
He read it right. He said it. He said
Yeah, Mr. Tepper misspoke. And yes, the motion's fine. The motion's fine. The vote is fine, the motion is fine. He misspoke.
So if you to guess what we were doing.
I was hoping that we could just gloss over it and save it for an office reprimand as opposed to out in public.
There's some pretty sharp people up here. Thank you very much, Merritt, for straightening that out.
No reprimand necessary.
There you go.
Thank you. I'm sorry, where were we?
The remaining matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth and their licensed gaming therein. In each instance, a petition for exclusion has been filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in the petition. The individual named in the petition failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment in each instance and properly served the same upon each named individual. Therefore, all facts in each petition are deemed admitted, all filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, if the board orders the proposed exclusion, the individual's photo, personal identifiers, and a summary of their inimical conduct will be placed on the board's public website.
The next matter for consideration is a petition to place James Smith on the board's involuntary exclusion list. As previously stated, between March 1st, 2018 and March 7th, 2018, Mr. Smith stole a total of $5,000 in gaming chips from Harris, Philadelphia, while on his shift as a table game supervisor for Harris, Philadelphia. At this time, OEC requests that the board issue an order placing James Smith on the involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of James Smith to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Dustin Miller, once again on behalf of the Office of Enforcement Counsel. The next matter today is a request for placement of Max Patterson on the board's excluded persons list. The Office of Enforcement Counsel filed a petition to place Mr. Patterson on the exclusion list due to an incident that occurred on November 21st, 2017. On that date, Mr. Patterson entered the back of the house secure area of Parks Casino with an underage individual through a construction entrance after twice being denied entry into Parks Casino through the employee entrance and the west entrance. Mr. Patterson was cited by Pennsylvania State Police for defiant trespass for his actions. Based upon the foregoing, the Office of Enforcement Counsel asks that the board place Max Patterson on the board's excluded persons list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Max Patterson to the PGCB involuntary exclusion list described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Tamara Haken once again with the Office of Enforcement Counsel. The next matter on the agenda for the board's consideration is the involuntary exclusion of James Zerfy. On December 31st, 2017, Mr. Zerfy grabbed a voucher valued at $851.16 directly from the hand of another patron and ran away with it, returning later to attempt to redeem the voucher. The redemption attempt was not successful, and the victim was made whole by the casino. As a result, OEC requests that the board issue an order placing James Zerfy on the involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of James Zerfy to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next on the agenda for the board's consideration is the request to place Eric Barnett on the exclusion list as a result of his arrest for robbery. Mr. Barnett assaulted and robbed a patron of $1,115 and his car keys in a restroom at Sugar House Casino. The charges remain pending in the Court of Common Pleas for Philadelphia, and he is currently scheduled for trial on December 10th, 2018. Accordingly, the Office of Enforcement Counsel requested the board place Mr. Barnett on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the addition of Eric Barnett to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Ashley Gabriel again for the Office of Enforcement Counsel. The next matter on the agenda for the board's consideration is a petition for the exclusion of Stephen Bird. While on the Sands Casino gaming floor, Mr. Bird attempted to take beverages from a beverage server's tray without placing an order, cursed at the beverage server, cursed at and was argumentative with security staff, and refused to leave the property when asked several times. Additionally, after Sands staff ejected him from the casino, Mr. Bird engaged in sexual activity with a patron in the parking lot in full view of the public. Mr. Bird then attempted to elude Bethlehem police during his arrest. Mr. Bird was permanently evicted from Sands as a result. He was charged with defiant trespass, actual communication to the actor, disorderly conduct, obscene language or gesture, and public drunkenness and similar misconduct. His charges are pending. At this time, the Office of Enforcement Counsel requests that the board exclude Stephen Bird.
Thank you. Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Stephen Bird to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. That concludes our business.
Thank you all. Next, we have a public comment period. As I understand it, we do not have anybody registered to speak today. Is there anyone here in the audience who wishes to make a public comment? Hearing none, that concludes today's meeting. Our next scheduled meeting will be held on Wednesday, July 18th at 10 a.m. in this room. May I have a motion to adjourn the meeting?
Mr. Chairman, I move we adjourn.
Second.
All in favor?
Aye.
All opposed? The meeting is adjourned.